The minister has the authority to order the telecoms to cease providing services to a specified person. There's a fear that we're talking about individual Canadians. Can you provide us with, like, you know, if you believe an individual Canadian is a threat to the telecommunications system, you know, there was degrading the system, disrupting the system, manipulating the system, why is there no requirement for a warrant in that case?
Freedom of speech and expression. The Canadian Constitution Foundation has raised concern about the civil liberties implications of Bill C-8, subclause 15.2. Would give the minister the ability to make decisions to kick someone off the internet. So my question would be, what safeguards are in place to prevent the government from using cybersecurity as a pretext for silencing speech?
There's been some groups like the Canadian Civil Liberties Association that have talked about encryption standards. There's a fear that this legislation will give unprecedented powers to break encryptions. Is there anything specific in this bill that deals with encryption breaking powers?
This guy's garage. Like and subscribe.
Bridget Walsh, Associate Head, Canadian Centre for Cybersecurity, and Mr. Daniel Couillard, who is Director General Cyber Partnership, Canadian Centre for Cybersecurity.
We had you for an hour just before this. It was in camera. We asked some good questions and we got some answers. And so for the interest of transparency, I'm going to kind of re-ask similar questions and hope that we can get the same answers. Now, I noted that under the CSIS Act for their threat reduction measures, that you have to get a warrant in order to move forward from the federal court. It's not clear under this legislation whether the government would need a warrant to move forward with the actions that they're giving themselves the power to do. Why is that?
Thank you, Mr. Chair, for the question. The powers under C-8 concern the ongoing regulation in terms of the security of underlying infrastructure. So in the instance of telecommunications, it's Bell's network infrastructure. They do not engage with certain charter rights or privacy considerations in that context. That's similarly how telecommunications operators are currently regulated. So, for instance, in the allocation of spectrum licenses that are necessary to run their wireless networks, that's currently an authority under the Minister of Industry. And there's no need for judicial oversight.
So we talked about a specified person in the previous hour, and you told me that they're a legal entity, not necessarily a natural person. There's a concern that when you have legislation that's written to say that the minister has the authority to order the telecoms to cease providing services to a specified person, there's a fear that we're talking about individual Canadians. Can you provide us with, if you believe an individual Canadian is a threat to the telecommunications system, there was degrading the system, disrupting the system, manipulating the system, why is there no requirement for a warrant in that case?
Thank you, Mr. Chair, for the question. In the context, if I understand the question correctly, for instance, in the regarding the authority to withdraw services from an entity. In that context, so first of all, the authorities are scoped in terms of needing to protect the Canadian telecommunications system. So that means that the individual commentary of Canadians or their ongoing traffic online is not germane to that, just in practical terms. So that would be in the context, for instance, of a distributed denial of service attack, which is flooding a network and preventing essentially the operation of it for other Canadians. The use of that authority needs to be reasonably necessary to advance the stated goal. So it can't just be on a whim. It needs to actually be tied to the gravity of the threat that's in question. And we are dealing with circumstances that where time is of the essence, where like these are services that Canadians rely on for life and death, to be able to call 911 or to do something, things of that nature. And so there are considerations about being able to move quickly.
Why the secrecy? Like, why are there the secrecy provisions provided in this?
Thank you, Mr. Chair, for the question. So generally speaking, the secrecy provisions are both not necessary and not like operationalizable. So when we're dealing with equipment that applies to all telecom carriers, like 99.9% of the time, we're going to be going out with a public consultation with rules, and we want everyone to know the rules of the road. There can be some specific circumstances where, for instance, an operator has a vulnerability in their network that's very specific, where disclosing that vulnerability would essentially invite hackers to like flood the zone while that operator is trying to get that under control. So that's the use case for the confidential order-making provision. It does include oversight, for instance, notification requirements to NCIRA and NCCOP so that they have line of sight and ensure that the power is being used appropriately. It's also subject to the annual reports to Parliament. So even though—
Is there an opportunity for judicial review? Like if somebody feels that these decisions are infringing on their charter rights?
Certainly, anyone can go to the courts with an application of judicial review. And
but what if it's secret? Like if they've been ordered that they can't say anything, how would they go to the courts?
We still need to consult the affected parties. Like that's a bedrock. That's a provision of the bill, and it's also a bedrock provision of administrative law. So, like though the entity affected still needs to have the opportunity to make their case about how the order may affect them. And they can go to the court, as well as, again, the notification to review bodies and the annual report to Parliament, which even if it doesn't disclose the individual, like the detailed nature of the order, still needs to describe the activities as well as their necessity.
Is there a time limit on those things? Like it says specified time. I only have 10 seconds left.
Yes.
So.
We have 90 days to notify NCIRA and NCCOP, and the report to Parliament is tabled annually.
Thanks.
Thank you, MP Lloyd, for these good questions.
How does placing the explicit responsibility on Canadian companies, the designated operators, to establish and maintain comprehensive cybersecurity programs, including steps to identify and manage risk associated with the designated operator supply chain and its use of third-party products and services to ensure compliance with the high Canadian security standards, regardless the physical location of the development or the support team is?
Thank you very much for the question. So I think this gets to a really important aspect of the bill. And as you say, the obligation is on the designated operator to make sure that any third-party services or products that they use are up to a reasonable standard to mitigate those risks. So the way this would work is that the designated operator would have a cybersecurity program in place, and they would have a plan for how they mitigate those risks, which means they would have a plan for how they would assess the various services and products that they might contract to be used in their networks. There's advice and guidance that comes from the Cyber Center, and they can use that advice and guidance to understand how best to identify the products and services that will maintain the safety and integrity of their network. And one element of this that will, I think, help the cybersecurity ecosystem writ large is that it means that the, companies that are selling their products and services to critical infrastructure will have to make sure that that their products are secure by design and that they're not sort of rushing to market and fixing potential flaws after the fact.
Thank you. So in addition In addition to the general risk mitigation, foreign state actors and entities from high-risk countries pose direct threats to our national security. How do the expanded emergency powers granted to the governor in council under the Telecommunications Act Part 1, specifically the power under the new Section 15.1 to prohibit a telecommunications service provider from using all products and services provided by a specified person, and direct their removal, provide the government with a precise and necessary tool to safeguard the Canadian telecommunications system against interference, manipulation, disruption, or degradation?
Thank you, Mr. Chair, for the question. Yes, so there are products and services that can be under the control of a hostile adversary, either in terms of the producer of those products and services being subject to extrajudicial oversight or other means by which that they could be used to infiltrate Canadian infrastructure. So in that context, especially given that software is increasingly important, the risk mitigation may not be possible in terms of using that equipment or service. And so therefore, the authority in question gives the government the ability to restrict its use entirely or to have it removed from the Canadian telecommunications system.
Thank you very much. So when considering the scenario where foreign support teams remotely access the runtime environments, it is critical that they adhere to the same mandatory security posture as Canadian employees, ensuring competitive fairness across the sector. So since designated operators must integrate steps into their cybersecurity programs to protect its critical cyber system from being compromised, how does the implementation of mandatory security standards and risk mitigation measures addresses the concern that companies utilizing international supply chains might otherwise gain an unfair economic advantage by circumventing necessary domestic cybersecurity costs?
So if I understand the question, it's a question, you're asking how a company would manage the financial aspect of having to mitigate these risks, and does it put them at a competitive disadvantage, is that right?
Correct.
Okay. So the bill itself does not directly address that. However, what we have looked at in the context of this bill is trying to ensure that we create a cybersecure environment in a way that does not put undue burden on industry. In this particular case, having a cybersecure environment is important because the bigger risk is an incident. One incident can outweigh years of profits and frankly incur so much damage that it would eclipse the expense of trying to keep the environment secure from the get-go. So the bill does not address it directly, but it is meant to protect the Canadian economy and protect the industries themselves in that way, just because the threat and the cost of a cybersecurity is so high if it were to materialize.
Merci beaucoup.
My question was, does this legislation now make it mandatory for all these operators to report every single breach that they may experience?
Thank you, Mr. Chair, for the question. So the mandatory reporting requirement appears in Part 2 of the Act. The answer to your question is no. It's not. What the intention there is the legislation will set out the requirement for mandatory reporting, and then the regulations will define exactly what that looks like. I had mentioned earlier that we have had some discussions with Five Eyes counterparts about what their mandatory regimes look like, and those have specifically been on the threshold for reporting. So our colleagues from the Cyber Center certainly aren't interested in receiving information on every single cyber incident. A lot of those are day-to-day things that everybody experienced that we have good traction on. I think what we want to understand is when there's an incident that has a certain level of significance, and so that's what we want reported in to the Cyber Center.
And then there's a mention of amps in this legislation. So do we have any sense as of yet what the highest administrative monetary penalties would be?
Yes, it's in the bill, and I'm sorry, I don't remember the exact number, but what I can tell you about it is that it's because this is a cross-sectoral framework and different industries have different thresholds, it's set high, but it will be set within a range that is typical for the industry that is being regulated.
Thank you very much. And then last question, if I may. In the information you've provided us, it says cyber incidents cost our economy $5 billion, with Canadian businesses paying nearly $7 million per data breach. Could you just roughly tell us why these data breaches cost companies so much? Are these attempt to pay customers because there's been privacy breaches, or why is it so large?
There are a number of factors. So the first thing that happens is if you have a breach, is a cyber incident or a breach, is that your data can be compromised. So the first thing is that you have to figure out what has been compromised, and that can be incredibly expensive just because you've got to bring experts in to come in and understand what exactly is going on your network, what's been compromised, what has potentially been exfiltrated. And then you have to start putting in place remedies not only from the technical perspective, but you also have to start looking at what your regulatory responsibilities are. Are you now not in compliance? There are privacy laws that are going to come into play, PIPEDA, Privacy Act, all of those types of things. There's notifications, there are lawyers that get involved, there are breach coaches that get involved. And so the costs mount. And the other piece that I think is a little bit more intangible is simply the reputational cost, right? Because often these will become public eventually, and then you start losing customers potentially. So that's how the costs start multiplying very quickly. I don't know if there's...
Yeah, I might add to that a little bit, say too, that from a technical perspective, it's the enormous expense that's paid, as my colleague pointed out, to remediate the situation immediately, but it's also the enormous cost in rebuilding and the losses in revenue that a business may have while that rebuilding occurs. So we know that there's a huge cost not just incurred in the immediate aftermath of the incident, but also in rebuilding their technology to get back up and running.
That is very good. Thank you so much. Ce qui m'amène à vous remercier. Maintenant, tous les...
I would like to thank you very much for having...
Really well, aren't we? So there's been some groups like the Canadian Civil Liberties Association that have talked about encryption standards. There's a fear that this legislation will give unprecedented powers to break encryptions. Is there anything specific in this bill that deals with encryption breaking powers?
Thank you, Mr. Chair, for the question. So there isn't a specific provision governing encryption. However, the ability to break encryption for the purposes of surveillance is out of scope of the powers here. Being able to access individual information for the purposes of law enforcement is certainly an important issue. It's a very hotly discussed topic. We've seen in C2, for instance, but it is deliberately out of scope of this bill. For instance, breaking encryption does not advance the protection of telecommunications network infrastructure. It just has nothing to do with that.
No, thank you for that clarification. I think the argument that has been advanced, and I apologize to these organizations if I've mislabeled their argument, but they talk about the term that the minister can order the telecoms to do anything or refrain from doing anything. And they're saying that that's a very broad kind of power that could lead to the breaking of encryption. Can you kind of describe why that power has been worded? I even thought to myself, like, that seems like a very interesting wording to use, refrain from doing anything or doing anything. It seems very broad.
Thank you, Mr. Chair, for the question. The wording is meant to capture the range of risks to the telecom infrastructure that can exist. And so, for instance, one may want to tell a service provider that they cannot use a particular product or service in their network, or that they need to take some positive action to protect their network. But again, a bedrock principle of statutory interpretation is that you need to look at the bill as a whole. For instance, the policy objective at the outset, sets the overall scoping. There are additional requirements, for instance, that the order-making power needs to be reasonable to the gravity of the threat, et cetera, et cetera. So those all still apply and structure the government's ability to act.
Thank you. And we talked about personal data. You've said it's outside of the scope of this. We've kind of gone over that. But the Intelligence Commissioner has stated in testimony that this power of the minister to ask the telecoms or to do something or refrain from doing something could give them the ability to ask the telecom providers to provide the private information of Canadians. And I believe the Privacy Commissioner has also raised this concern. Can you elaborate on those concerns, and are they a concern, and why not if not?
Thank you, Mr. Chair, for the question. So the Information Collection Authority in Part 1 is modeled off of the existing Section 37 of the Telecommunications Act that has been in place for decades without incident. It just carried forward because it needs to be applied to the new security network protection authorities. It is still structured within the scope of what can be done to protect the Canadian telecom system and not to advance general security or law enforcement aims. So it is still limited to the order-making authorities and the protection of Canadian telecom systems, as opposed to and cannot be used to advance a generalized fishing expedition or investigation into personal information.
Thank you. And in my final time, how is it determined if the minister's decision under this powers is reasonable? Who determines if that's a reasonable thing that the minister has done?
Thank you, Mr. Chair, for the question. At the outset, first there is consultation on the rules, and we are required to take into consideration what those views are. And then there are notification and transparency requirements after the fact, and then ultimately all decisions of the minister are reviewable by the courts. And the telecom operators are not shy to go to the court. They are, well-resourced and frequently make use of that avenue.